You really couldn't make this up even if you tried really hard, but it does give you an idea how headlines can spin things depending on your subjective viewpoint. Do you remember the lawyer pictured in the middle here who originally represented these two men beside him in the Manchester airport incident who've now been charged? Well, the lawyer, Ahmed Yaqub, has been detained by his own admission by counter-terror police at the Channel Tunnel. So in this video, I'm going to talk a little bit about that. It's broadly from his own words as reported, but as I said, headlines can spin things. Then I'm going to talk a little bit about what happened and why he sort of disappeared from the picture. Now, of course, I'm not going to comment on the charges against the two men in question because that is an ongoing case and I'm not going to do anything to prejudice the trial whatsoever. So none of this is to be taken as a viewpoint regarding that. But first of all, if you are new to me, I am a barrister of England and Wales. My name is Daniel Shensmith. I'd be really grateful if you would subscribe to the channel. I depend on you, the viewer, to help my channel grow. I am not the mainstream media. I'm no part of it whatsoever. So I really appreciate you subscribing. So let's take a look at what happened here. And I'll come back to, as I say, the original representation and some thoughts about that generally, you understand. But let's look at his own reporting, first of all. It appears that he spoke to Birmingham Live, which then reported on it, and I suspect that they've given a headline which is a little bit provocative. He may not be happy with the headline, actually, because the headline says that he's been detained by counter-terror police at the Channel Tunnel, which is factually correct, but it may not come across to some people the way he might have wanted it or intended it to. Nonetheless, he said he was stopped by UK border officers and questioned by counter-terror police. We'll look at the Terrorism Act in a moment because it's an important piece of legislation. Some people think you have all sorts of rights, etc., but when counter-terror laws come into play, you have very little leeway here. He said he intends to submit a complaint about his detention, which took place under Schedule 7 of the Terrorism Act. Now, with great respect to him, I personally think that complaint will go nowhere because they can detain you under the Terrorism Act under Schedule 7. I'll come back to that in a minute. And that would be just for their investigatory purposes, and that will probably be the end of that. But he said he was detained for 6 hours. I mean, I might be wrong. The complaint might go somewhere, but it probably won't. He said he was detained for 6 hours, which is the maximum permitted under the schedule, unless, of course, there's other developments or whatever. He said they asked about his mayoral campaign. You remember that he was pictured in front of a building, I think it was in Birmingham, and his views about Gaza, and whether he knew anything about Hamas, about Hezbollah, what he thought of the Gaza situation, his political campaigning, who funded the political campaigns, whether he intended to stand again. And of course he said, yes, I do intend to stand. Now, of course, counter-terror police are entitled, in fact, they have a duty to investigate and ask questions of all these sorts of things if they have any sort of reason. Now, I'm not saying for one moment that any of those reasons are justified and valid in this case here, but they were essentially doing their job, to coin a phrase. He said he was allowed to leave after the detention period and was not arrested. He's waiting. He said he's waiting for the return of his electronic devices, which can be kept under 7 days under the Act. Birmingham Live said it's seen a document to confirm that these devices were detained as part of counter-terrorism inquiries. He said he granted the PIN to these devices after receiving assurances that legally sensitive information with involved clients would be first assessed independently and protected. And that is, of course, because information on a device, I mean, such as my device here, mine are fairly secure in the way that I access documents. But, and I won't even divulge how that is for the purposes of security, but any device that may contain legally privileged information, they have to take special care because, of course, it's got client information on there, etc. He said that they intended to belittle him and question him about his political motivations, etc. It does beg the question as to why they felt it necessary to detain him. But what he did say is that he was heading home after spending time travelling in Europe, including seeing clients, accompanied by other lawyers, 2 friends, and was detained initially by border police as they arrived to board the Euro tunnel. So what do we know about the Terrorism Act? Because it's a fairly robust piece of legislation, and there is a power to stop, question and detain under this act. And if I jump first of all to the interpretation of what an act of terrorism includes, about which they might see the cause to investigate, ask questions, etc. Even if they think someone just has some information about it, you will recall that even Tommy Robinson was also detained under the same act because they presumably felt that he might have information that they would need to ask him about. But an act of terrorism generally falls under this act if the use or the threat is designed to influence government or international governments, or to intimidate the public or a section of the public, or the use or threat is made for the purposes of advancing political, religious, racial or ideological causes. An action within this act falls if it involves serious violence against a person, serious damage to property, endangers a person's life other than that of the person committing the action, serious risk to health or the safety of the public, designed to seriously interfere with or seriously disrupt electronic systems, etc. And various things throughout this act that would have this sort of effect that they might want to question about. So what could possibly be the purpose that they stopped Ahmed Yaqub? Well, I'll tell you exactly what the terrorism searches and detentions and questions are supposed to be for in just a moment. Don't go away. Now, as an aside, it is still very much New Year, even though January is almost coming to a close, believe it or not. But I'm here to help you with a plan for New Year, New Me. Now, many people have tried dry January and are struggling with giving up alcohol. I did that a year and a half ago, but my plan this time, my New Year's New Me, is to give up soft drinks and even the zero sugar soft drinks. And for that, I am greatly helped with a partner for my channel, which is Holy, who produce energy drinks, hydration drinks, and iced teas. Now, they're not the kind of energy drinks that are full of sugar that many of you might think they are. They are sugar-free and full of vitamins and antioxidants. They come in a huge range of flavors and are really easy to make. Whether you use a shaker or a bottle, you can fill them up with water, 1 spoon of the powdered drink, and give it a good shake, and you get yourself a really delicious drink. My favorite flavor by a long shot is the strawberry and kiwi. It is really tangy and tasty, and I drink lots of it. But not only that, if you're looking for something even more delicious to tempt you away from the soft drinks, they now do a range of milkshakes, which are absolutely fantastic. So I was really excited to find the hazelnut milkshake, which with a little splash of milk, 1 spoon of powder, and you get yourself an amazing milkshake, which is really delicious. It's really hazelnutty. I mean, this is a real weakness of mine. I love hazelnut drinks. Just like you go for a hazelnut latte or something like that in a coffee shop, these are absolutely brilliant. But just like their other drinks, you can be sure that they are zero sugar, packed with vitamins, and really delicious. But you'll have to be quick though, because I think the hazelnut is limited edition, unless I can convince them to do it as an ongoing flavor, which, if I have anything to do with it, I will be making sure that this is on the menu for a long time. Of course, as a partner to my channel, you get a fantastic discount, which is 10% off if you use the code Barrister, or £5 off if you like straight round numbers with the code Barrister5. But also, as a new customer, I would recommend you get their Starter Set Deluxe, which at the moment comes with a free glass bottle like this one, which I think are also limited edition, a set of stickers for New Year, New Me, free shipping, and a full range of 42 different servings of different flavors, so you'll know which ones you like best. As I say, they have hydration drinks, energy drinks, and iced teas that you can sip in the evening, all replacing your soft drinks and alcohol and everything else, whilst keeping you deliciously entertained. I have to stress, the hazelnut milkshake is absolutely to die for. It is just like a hazelnut latte from the coffee shop. I really like this one. And what's even more amazing, I'm getting carried away now, but if you go with the milkshake mega bundle, not only do you get all 3 flavors, the vanilla, the banana, and the hazelnut, my favorite, but you get 3 shakers to go with it. So a big family deal. I think you'll really love them. Check out the links in my description with the discount codes. Barrister for a 10% discount and Barrister5 for a £5 discount. And thank you to Holy for sponsoring this video. So if somebody is stopped, detained to be searched and questioned under Schedule 7, the important thing is there is no need for any reasonable suspicion. It is merely a power to do so. So under paragraph 2 of Schedule 7, an examining officer may question a person to whom this paragraph applies for the purpose of determining whether he appears to be a person falling within section 41B. So there doesn't need to be a reasonable suspicion. They have the power to stop and question somebody in order to determine whether they're a person falling in section 41B. I'll come back to that in a moment. And then once detained under paragraph 5, a person who is questioned under paragraph 2 or 3, paragraph 3 relates to Northern Ireland, under paragraph 5, a person is questioned, they must give the examining officer any information they possess which they request, give the examining officer on request any valid passport, including photographs, declare with him if he has any documents of any kind specified, and so all of this would apply to mobile devices, pins, etc. The person detained and questioned and searched must give all of this information under paragraph 5. Searches come under paragraph 7 and 8. They can search the person, any vehicle, anything they have with them, anything they believe they have with them, or anything they believe is on any vehicle, and so on. And so coming back to paragraph 41B, now reminding ourselves that the power to stop, question and detain under paragraph 2 is for the purpose of determining whether someone falls within section 40 sub 1 sub B. So there's no reasonable suspicion required. This is, they have the power to stop and question, detain and question to determine whether or not they fall within this section. And this section says it's under part of the definition of a terrorist. It is under section 1B, anyone who is or has been concerned with the commission, preparation or instigation of acts of terrorism. So again, I stress this is not to say that this lawyer it has anything to do with any of this, but by his own admission he's been stopped, detained and questioned under the Act, and so they have a power to do that without any reasonable suspicion. They don't need any suspicion or evidence or anything of any kind, but they do that in order to determine whether they are or have been concerned with the commission, preparation or instigation of acts of terrorism. So I thought you'd find that interesting, because that can apply to anybody, whether you've ever had any involvement whatsoever. They have the power to stop and detain you and question you. You must give them the PIN number, you must give them documents, they can search anything, they can search any vehicle. You have next to nothing by way of rights when it comes to this schedule under the Terrorism Act. So that I thought you would find very interesting. But now we come to the question as to why he quit in the first place. And I'll make it clear here that I make no criticism of him here for what he's done, what he's said, etc. But he was the subject of criticism after he made statements. And now this, again, these are not my comments about the ongoing trial as it was. This is commentary on the reporting as it was at the time. So not to be confused with that. But he was the subject and focus of criticism at the time because of comments made. Now, comments such as one of the men in this case, he says, was the victim of an attempted assassination, left him fighting for his life. Now, of course, those men have been charged, and so the evidence will be put to the court, and the judge will direct the jury as to what they should consider and what they should discount. And so any of this reporting, now in my view as a lawyer, whilst there's an interesting quirk, because it used to be the case that we were not allowed to comment on our cases at all, much less those that were live, but now those restrictions have been lifted. Barristers or lawyers can generally comment on their cases, even if they are live, bearing in mind all the while the rules of contempt of court, not to say anything that has a serious prospect of jeopardizing or prejudicing a trial. But most of us lawyers just wouldn't do that. I don't know many lawyers that would actually make public commentary such as this, much less direct comments about the individuals involved who may later be subject to a charge. And in this case, they were charged, of course, after many, many months. But most lawyers I know just wouldn't make those comments. So one possibility is that he had this criticism and decided to step aside. Another possibility is that it does take a lot of time, and he may have felt that it was too much work for him to do. It may have been, of course, that the two individuals just decided to go with different legal representation, which is always possible. You're, of course, at liberty to instruct a different lawyer. There are some rules that apply to legal aid and so on, but interesting quirk is that barristers don't advise on legal aid, the availability of legal aid and how that works, etc. That is solicitors that undertake that role. But as it's reported here, Ahmed said that the media tried to sabotage him once he started representing the family. Now, that again is understandable and quite possibly quite unfair on him, because Obviously, this case attracted a lot of media attention, and thus any lawyer representing them would come under a lot of media scrutiny as well. So again, maybe that's another reason. He said here, the media tried to sabotage me. It's not the first time they've done this. They've made this whole situation about me rather than the police brutality, etc. His words, not mine. Which he says was grossly unfair. So after consulting with the family, I've decided for now to step aside and recommended the family to a lawyer. But I'll be keeping a close eye on the case. But as I say, overall, there were some fairly bold comments about that case in general, some of which I wouldn't repeat, because even repeating those I think would come too close to a line, so I wouldn't repeat those. But as I say, most lawyers I know wouldn't make those sort of comments and generally wouldn't comment on their own cases. If you're a lawyer and you watch my channel here, I know many of you are, let me know in the comments generally what you would feel about commenting on your own cases, particularly as they are developing, even pre-charge. I know most lawyers I know just wouldn't comment on those cases as they're going on. Even old cases, unless they can be sufficiently anonymized and generalized, they wouldn't comment on those. Unless, of course, it relates directly to you, the lawyer, individually. There's a case against me, which is just about to wrap up, which I will be commenting on. I'll be talking about it in full, because there's a lot of detail in that case that I think a lot of people need to know. How the system works, how it can feel extremely unfair, and how it can be dragged along for a long time, take up a lot of time. And ultimately, for those that don't understand the system and don't know how to navigate this legal world, I think it could be quite distressing for most people. Because most people would probably give up. Most people would probably just agree to something to have a case settle or conclude and end. Most people would take a bit of money to have it conclude and end. But I'm in the category that I know how to deal with it. I don't get stressed by it. It's just a matter of course for me, because I understand how cases work. I don't need to take a settlement to have something conclude. I would rather see it through to a proper conclusion, whatever that conclusion might be. And so I will talk to you about that in due course, very shortly, and you'll get the full details. So I hope you'll stick around for that. If you do want that, please do subscribe and hit the notification bell, so then you'll get notifications of new videos, because that will be probably in the coming weeks or maybe a month or so. So do stay tuned. Thank you for watching, as always, and I'll see you next time.